Welcome to another episode of Judge for Yourself. The Oscar Pistorious trial made history. It was the first court case to be televised live in the country. The decision to allow cameras into the court was granted on the basis it was a case with such high public interest that justice must be seen to be done. But now serious questions have been raised whether the live broadcast influenced witnesses, put undue pressure on the judge. The real question is this a precedent that we should repeat? And perhaps a subsidiary question, are the public better aware now? Do they know more? Do they understand more about the intricacies of the criminal justice system than they were prior to this particular case being televised? If you'd like to join the discussion on Twitter, please use the hashtag JFY Broadcasting Trials. To discuss this topic, I'm joined by Advocate Gcina Malindi, Senior Counsel at Johannesburg Bar, Dario Milo, Media Lawyer from Webber Wentzel, and Professor James Grant, Expert in Criminal Law at Wits University. So let me start with you, Professor Grant. Well, I mean, you were sort of all over the media, weren't you? I mean, I don't know if Dr. Milo was. I mean, but you were. I mean, do you think that this is something we should have again?
Overall, I would say yes. I would say that it was an invaluable teaching tool.
To you or to
my students. I could.
Why do you say that?
Because throughout this year in particular, I was able to point to the proceedings of the Pistorious case to illustrate the points that I was trying to explain to my class throughout. But it went beyond that. I found that I was able to talk to tellers in shopping centres, to barbers, to anybody virtually about things like dolus eventualis, of all things.
Yeah, I'm not entirely sure that anybody knows more about the concept than they did beforehand.
Well, that's because the law is utterly confused.
No,
so
the
now
law
the
is
general public
the law is clear.
Yes.
Everybody has to read S versus Humphreys. The law is clear.
Well, there's a debate about that because there's an internal conflict, and I think what's happening is that the public are about as clear as on dolus eventualis as the law has been for a long time. The point is, I think, that people got to see, and they now understand a hell of a lot more than they ever did.
Do you think that? I mean, you've sat as an acting judge too, so you would have had some idea of what it must be like to be televised, and you're also a silk. And I'm just intrigued from your experience. Would you like to have appeared in a case which had been wholly televised?
Maybe.
Was that a leading question that I shouldn't ask you?
I think the judgment of Lambo JP gives a guideline of how a court that is regulating the process in such situations where a request has been made for televising or placing audio equipment in court should take into account in deciding whether to grant such a request or not. Maybe the Pistorious case was not the ideal case as an educational tool to the public out there.
Why do you say that?
Because it was such a high-profile matter, and it involved
Celebrities.
Legal engagements by lawyers at the highest possible level, whereas the day-to-day proceedings in court are not what we saw.
Yes, exactly.
And the process should have started as an educational tool with everyday cases in the divorce court, in small criminal matters, so that people are not overwhelmed by what they experienced through this trial.
So Professor Grant says it was an educational tool. The barbers and his barber and his, the bar steward, whatever it was, and his students at Wits who also may be bar stewards, they all learnt a lot. Mr. Malindi says, if you really want to learn, you should see what the ordinary criminal trial is. And frankly, these celebrity trials give you a distorted picture of the whole business.
Well, I think there's truth to both of the comments that have been made. But for me, one needs to look at the principle that's involved. And in principle, the difference is between first-hand accounts of what happens in court versus second-hand accounts. Twitter, news reports, whether it's radio or TV, summaries, a 1,000-word article in the newspaper the next day. That's what we're used to. That's what we get. Whereas this allowed us to watch firsthand how this particular criminal trial took place. And I accept that, of course, there are many trials that take place in the Magistrates Court. There's, of course, small claims court that one needs to be educated about. But that's certainly not an argument for saying we shouldn't have broadcast the Oscar case. It's an argument for saying we should be broadcasting more court cases, in my view.
All right. So the argument would be that then you would say more criminal trials should be broadcast.
Absolutely.
But then you have to accept that the Oscar Pistorious case didn't necessarily give you a realistic view of what goes on in an ordinary criminal trial with an ordinary common law accused being defended by a pro bono counsel.
Yes,
and with an inexperienced prosecutor on the other side.
Absolutely. And I think that that's the point about trying to ensure that broadcasting takes place across the board as far as possible, is that disparity between the rich and the poor has to be ventilated.
What about the pressure on the parties? What about the pressure on the judge? What about the pressure on the defense and the prosecuting counsel? What about the pressure on the witnesses?
Well, insofar as the judge and the lawyers are concerned, that pressure, of course, would have been there, and in fact the witnesses. The pressure in a high-profile case is there anyway.
I can't help, however, Dario, to compare this case to the Dewani case. There's an entirely different mood that's prevailing these two cases.
And I must tell you that I know far little about the Dewani case than I do about the Oscar case, because I have to rely on second-hand accounts. So if you ask me if I know what's going on as a busy practitioner in the Dewani case, I don't know much about it except for sort of summaries at the end of each week.
But then isn't it running in the way that a trial should run, without all the hysteria and the vibe?
It's running, the Dewani case is running in the old traditional mold.
What's wrong with the old traditional mold?
I think the fundamental problem is it doesn't update, for want of a better word, the principle of open justice. It comes from an era when we relied on shorthand court reporters to get our news about courts. I mean, look at how Twitter has changed the nature of court reporting. It's instantaneous.
Instantaneously poor.
Well, that's not an argument for saying you shouldn't do it. It's an argument for saying
the
educate
freedom of expression
journalists.
can mean you've got freedom to write rubbish. I accept that.
Yes, yes.
Right? But what I'm saying is that why would some more reflective sort of journalism not have been far superior, which we haven't had at all?
I think you need a combination. I think you need the live broadcast as a general rule. Obviously, there will be some exceptions if a case is made out for that. But you also need deep analysis.
Well, we're going to come back to this, but I must take a break first.